Randy Barnett is a professor at Georgetown University Law Center of Legal Theory. He is the author of numerous books on the Second Amendment and other constitutional issues. And I'm so pleased to be joined by Professor Barnett right now here on Jimmy at the Crossroads, again, coming to you in partnership with the Washington Examiner. Professor, welcome to Jimmy at the Crossroads. It's good to talk with you, sir.
Well, it's good to talk to you too, Jimmy. I hope our video connection is okay.
What's interesting, though, is when we're talking about fundamental rights and actually having the court intervene, that's protection, I would say, of rights that are enshrined in the Constitution and being overridden. That is the Constitution, the supreme law of the land, and being overridden by statute. And it's, in this case at least, restoring back to the original intent, hence why originalism became something that conservatives really adopted more vigorously, because they recognize we have to protect these unalienable natural rights that are guaranteed and enshrined in the Constitution and in the Bill of Rights. That's what the Founding Fathers had intended, what the framers thought was necessary to include in these amendments and in the overall Constitution, depending on the particular issue at hand. And I think that is critical. And I don't understand at this point in time, when we've seen such an erosion of constitutional liberty, Professor Barnett, how that old sort of more conservative mindset on these types of issues especially is taking hold so much, especially in the mind of Chief Justice John Roberts, who's a very intelligent guy and also clearly is very familiar with the ideals of originalism. Ideas.
Well, he's not an originalist, for one thing,
right.
and he's old enough to be the old style judicial conservative. But let me just say, it's a very interesting story, Jimmy, and it's a complicated one. And I wrote a whole book about just this story, and it stemmed from my experience as one of the lawyers in the Obamacare challenge who devised the argument that the individual insurance mandate was unconstitutional. We got 5 votes that our argument was right, but we didn't have 5 votes for actually invalidating the statute because we lost Chief Justice Roberts. He agreed with us that we were right, that it was unconstitutional to make you buy insurance, but he figured out a way to defer to the legislature by changing the law so that it wasn't really a mandate. I wrote a whole book to explain how this happened and why it happened. It's called Our Republican Constitution: Securing the Liberty and Sovereignty of We the People. It's my trade book, which is aimed at a general audience. So if anyone wants to know how we got ourselves into this position, where a conservative Republican like John Roberts could come out against the Constitution or enforcing the Constitution in the Obamacare case and would likely do so again in the right to keep and bear arms cases, you have to read that book.
Now, real quickly, this is sort of a detour, but since we're talking about John Roberts, one of my arguments, and I agree with the judicial restraint notion of that more classically conservative view of the courts, but I also think, Professor Randy Barnett, that a lot of what Roberts looks at is, in the Obamacare case, seems to be an indication of this, in my view. He also looks at this sort of from an institutionalist standpoint. That is the idea of, let me protect the institution of the Supreme Court, particularly from public perception that might make our status within society a little more diminished if we are challenging and overturning popularly approved laws. And I go back to the switch in time that saved 9 when FDR was saying, hey, we're going to pack the court, we're going to pack the court. He ends up not packing the court, but the Supreme Court suddenly does an about face and starts upholding various New Deal laws, legislation that they had been previously striking down, New Deal legislation, and they started upholding New Deal legislation. It's known as the switch in time that saved 9, helped to prevent the packing of the Supreme Court at that point in time. And I think that was an institutionalist notion that was embodied in this idea of the switch in time that saved 9, and that John Roberts is sort of carrying on, at least to an extent, a sort of legacy of that. What do you make of that thought?
Well, first of all, I want to agree with you about the institutionalist point. I think that's exactly right about him. On the other hand, in my book, I explain why the switch in time that saved 9 story is actually not accurate. In fact, the switch had begun earlier. It actually involved a justice named Roberts, Owen Roberts. It had begun earlier, and it took longer to happen than in just that instant moment. And it's a result of appointments to the Supreme Court that took place over time when presidents would appoint judges that were more friendly to progressive legislation as a result of the politics of the day. So the change happened, but it didn't happen just that way that story tells it. I will say, though, let's get back to the main point, the institutionalist point, because I agree with you about that. Because I think it's called the Roberts Court, we're in trouble. We're in more trouble. If he were an associate justice and not the chief justice, I think he might be doing different things as an associate justice. But because the court is named after him, and he's concerned with the legacy of the court, because he's concerned with his own legacy. Yes. He wants to preserve his legacy. And he identifies with the court. And as a result of that, he wants to get the court out of the crossfire, out of the political crossfire that ruling and upholding the Constitution would put them in the middle of.
And I would say it's not just because of the idea of the Roberts Court, but he thinks as Chief Justice, he has this sort of fiduciary responsibility to stand for the institution of the court. So a very fascinating discussion. I want to wrap up by getting back, though, to the Second Amendment and the significance of the Ninth Circuit Court of Appeals decision in the context of the sort of reshaping of the judiciary that we're seeing under President Trump. When President Trump took office, my understanding is that there were 11 more Democrat-appointed judges on the Ninth Circuit Court of Appeals than Republican-appointed judges. And now it's just 3 more Democrat-appointed judges than Republican-appointed judges on the Ninth Circuit, which has been known to be a very liberal, the most liberal Circuit Court of Appeals in the country. Talk to us a little bit about how you think this decision by Judge Lee and the other conservative judge on the Ninth Circuit helps to underscore what's happening in the broader changing mosaic because of President Trump's judicial appointments.
Right. The composition of the judiciary is changing now the same way it changed back before the New Deal. A president is elected who has a certain view of what kind of judges should be put on the bench, and a Senate is there of his own party. This is what FDR had. A Senate of his own party is there to ratify those choices, and that is how the court changes over time. It's the way it's designed to change over time, and it has, because Donald Trump happened to win the election of 2016. It's going to change more again if he does not win re-election in 2020. Not only that, but the Democratic Party platform specifically calls for expanding the number of lower court judges so that more judges could be put on the bench by a Democratic president and presumably confirmed by a Democratic Senate. And it identifies litmus tests on such issues as abortion and other cases that those judges must pass before they're put on the bench. In other words, expand the court. This is the court packing scheme that Roosevelt proposed for the Supreme Court. Expand the number of judges, so you can flip these circuits back. They're not all flipped in a conservative direction yet. The Ninth Circuit is 16-13. But that's what we have in store for us if Joe Biden wins the election.
And Kamala Harris, the vice presidential nominee now, she was just formally nominated this week at the Democratic Party, has explicitly said this too, and I think she would even like to see the Supreme Court expanded to more than 9. Now, why do you think that's problematic, Professor? The idea of expanding these judicial appointments.
It's not constitutionally problematic because Congress has changed the number of justices since the very beginning. We started off with 6 justices. Then to 5, then it's been as many as 10. Then it's been at 9 for a very long time, however. But there is a problem with a principle of expanding the number of justices because you don't agree with the justices who are on the bench, because you want to politically pack the court with justices that you agree with. Frankly, if this had been a permissible move, then the Republicans could have done this. And why didn't the Republicans do it? And what would the Democrats have said if the Republicans had done it with a Republican president and a Republican Senate? In order to do this, however, they're going to have to abolish the legislative filibuster in Senate, block this sort of thing from happening. And that is something else that many Democrats favor these days, which is going to allow them to implement a lot of their program in a way that Republicans have been unable to do because Republicans have maintained the legislative filibuster.
Very interesting. Professor Barnett, any final thoughts before we let you go today? And I really appreciate your time.
Well, it's a pleasure to be with you, Jimmy. I just urge people to buy my book, Our Republican Constitution, but also
Absolutely.
I have a new book called An Introduction to Constitutional Law, 100 Supreme Court Cases That Everyone Should Know. And that book explains the history of constitutional law. It's not about the original meaning of the Constitution. It's about what the courts have done about the Constitution from the founding until now. And if you buy that book, which is about $23 on Amazon, you get a link to a 63 video series that my co-author Josh Blackman and I created to watch. And it makes all of these cases come alive. It's like taking a course in constitutional law without having to pay tuition for Georgetown law.